Hello, my name is Lauren Lane, and I'm doing my executive presentation on Michigan's Elliott-Larsen Civil Rights Act, specifically the height and weight discrimination. This law was created in 1976 at a state level that is specific to Michigan itself. Its purpose is to prohibit discrimination in Michigan on the basis of religion, race, color, origin, age, sex, height, weight, familial status, or marital status in employment, housing, education, and access to public accommodations. This meaning that no person is allowed to discriminate against another person based on these characteristics when applying to jobs. For example, the Elliott-Larsen Civil Rights Act recently got a new expansion that protects LGBTQ+ members' rights as well. According to Michigan Senate Republicans, there are many Michigan anti-discrimination laws in prior place to the Elliott-Larsen Civil Rights Act back in 1885. The new additions of including LGBTQ+ members' rights along with the other basic rights that are prohibited to discriminate against a person for has a similar federal counterpart. Justice Neil Gorsuch wrote in the majority opinion in Bostock versus Clayton County, Georgia, that it is impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex. This anti-discrimination law is very similar to that of the Elliott-Larsen Act in Michigan. This presentation will focus on the height and weight components specifically of this act and how it is illegal to discriminate based on these characteristics of a person. On the Department of Civil Rights' page of the State of Michigan website, it discusses that the Michigan Department of Civil Rights is the one who enforces the state law of the Elliott-Larsen Civil Rights Act and any amendment that may be made to it. Complaints of a violation must be reported to Michigan Department of Civil Rights within 180 days of the discriminatory act. The claim will then be reviewed by the department and fully investigated. Employers must comply with this act as it is a state law which can lead to serious consequences if violated. After a claim has been reported to Michigan's Department of Civil Rights and it has been investigated, it is then determined if there was or was not a violation of the Elliott-Larsen Civil Rights Act. In the event of a violation being proven, the claim will be taken to court as an act of discrimination. According to Michigan.gov, respondents may have their certifications or licenses, if applicable, removed or revoked or suspended. Additionally, a contracting agency shall take appropriate action to terminate a contract or portion thereof previously entered into with the respondent. This can be harmful to businesses, especially if there were to be a discriminatory claim made against them. In the first example of the height specific case of Elliott-Larsen Civil Rights Act being violated, I was able to find an article titled "It Pays to Be Tall, Height Discrimination is Real, and It Can Be Economically Devastating," which described height discrimination. Since the Elliott-Larsen Civil Rights Act protecting a person from being discriminated against because of their height is a Michigan-only law, this example is true that there would be a violation if it were have happened in Michigan. The study done in the article was done in 2020, where the data of 3,500 adults were analyzed based only on their height and their pay rate. It was found that every additional centimeter of height was correlated with a 1.3% increase in a person's annual income. It may seem silly, but people who are shorter are seen as weaker or unable to complete certain tasks. This gives taller people the advantage and are more apt to getting hired quicker or even pay raises. In the second case that I found, it is more descriptive towards the weight component of Elliott Larsen's Civil Rights Act. In this particular violation of the Elliott Larsen Civil Rights Act, it's found on an article published in PubMed. In this article, it describes the case study of both male and female young adults that focused on body mass indexes and if there was any correlation with lowered wages and higher BMIs. The case found that young adults facing obesity was linked with 3.5% lower hourly wages. This may be caused by many reasons, some possibly being that employers view overweight people as not good workers or lazy. If this were particular to Michigan, this case would be a direct violation with the Elliott Larsen Civil Rights Act. When ensuring compliance with the Elliott Larsen Civil Rights Act in my organization, I think education is key. Staff members and management must be educated on what constitutes as discrimination and what protected classes are involved. Managers must be careful when making decisions for or about employees that they aren't being discriminatory against anyone. As stated in employment law for human resource practice, managers must not make employment decisions based on the protected class characteristics of their employees. This can be as little as a height restriction for a certain type of job. An additional way to ensure compliance with anti-discriminatory laws is knowing if your employees have any disabilities and providing them with accommodations if necessary. Failure to recognize and provide accommodations may result in a discriminatory claim against a disabled person. The Elliott Larsen Civil Rights Act includes protection for everyone from discrimination against religion, race, color, national origin, age, sex, height, weight, familial status, or marital status in many public relations. The Act is enforced by the Michigan Department of Civil Rights and is addressed at state level. The cases where the Elliott Larsen Civil Rights Act was violated are examples of how discrimination is prevalent and can affect someone's daily activities. It is important to address these concerns and reduce the amount of discrimination. Education is a key tool in being able to reduce said concerns of discrimination in the workplace. And here are the references.